Honorable Court, now resume. Please sit.
Good morning. We have representations remain the same, so we may proceed. Sorry, I will call up have the matter called up.
Application for leave to appeal, criminal appeal number 25 of 2016, Cecil, Moore, and the King.
Thank you. Madam DPP.
Lady. May it please you, my Lady President, may it please you, Lords and Ladies of the Court of Appeal. You know, my lady, although yesterday should have been really a rest day of reflection, the arguments and the case was still going around in my head. And before I leave 42K, just to indicate that I do understand, and I take your ladyship's point, that the court, being a guardian of the Constitution, should without more be perhaps even the first vehicle that any judge would use in terms of making sure that the pretrial remand is credited in order to make sure that the ultimate sentencing process is just. And I noticed when I looked back on Worst, they kept on speaking about just, which is what which is how I also looked at it. Why I kept riveting your minds when I looked at 42K to the word just. Yes. That is really what it is. But, and I'm going to say this very carefully as I look at my Lady Edwards. As it relates specifically to the issue of giving credit for pre-sentence custody or remand, where the minimum mandatory sentence has been mandated by law, we would submit that while the sentencing judge would always have as the first recourse the issue of safeguarding the constitutional right to liberty of the accused, nonetheless, we would submit that this remedy should not be seen as being mutually exclusive of the other vehicle that has previously been promulgated by the Parliament under Section 42K of the Criminal Justice Administration Act. And I say this my lady president.
One second. Do you agree that when Parliament was dealing with Section 42K, which really predated our acceptance and embodiment of the Kalachan principle, that that section focuses on the sentence itself, which means having applied the principles of law pertaining to sentence, when you arrive at a sentence, you realize that the minimum, it takes you somewhere below, which would suggest that the minimum now would be disproportionate and unjust, then that is what triggers 42K, because the credit is applied post-sentence. It's as if you have to arrive at the sentence. So
that is so, my lady.
I don't think we should, to my mind, and I don't know if my colleagues agree, the conflation of the sentence, because the court would say the minimum is not disproportionate, But even if it's not disproportionate, the man is entitled to be credited.
That is so,
and
so
that
the sentence would not be unjust.
Yes, so
that is so.
Disproportionate, right, it would not be unjust. Because
that
ultimately, the case law is really, when you get down to it, it's the interest of justice that you're giving effect
if I
to.
may be permitted to use that phrase as a humble prosecutor.
Madam DPP.
But if I may, before your lordship, because this...
No, sorry, what we're trying to get from you is whether you are saying, even though a judge may recognize, having come to the end of the sentencing process by applying the principles, you find that the minimum is not disproportionate and unjust. But given the time the person spent in custody, they ought to be credited, or not given the time. Once they are in pre-trial custody, they ought to be credited. The judge, seeing that, should say, therefore, rather than dealing with it there in the interest of justice, which we are all there to do, I'm going to issue a certificate for the Court of Appeal.
Milady,
so that's what I'm understanding.
Milady, may I be permitted? It is important that the Duncan case recognize that though the system may be fair, it is not infallible. And with your vast experience, you would have seen, I certainly have seen it, where all sorts of things can happen. In talking to my colleagues on this side, let us look at a hypothetical situation. All of what your ladyship and my lords have been saying is predicated on the bona fide source of the information about pretrial remand. But if it is, in the unlikely event, that the sources of the information as it relates to how long the pretrial remand has been taking place, and there was, for example, corruption in the system, my lady, whether criminal records or otherwise, corrections, I've seen it. I've seen it. And if there was corruption in the system, and say, for example, that the accused had been on pretrial remand really for 2 years, but the information coming says 5 years, and without more, the learned trial judge, and all of us, we take that, and we go ahead, and he's credited with that.
Madam DPP,
I'm just trying to think outside the box.
If I could come in here, though, because
I'm just trying to think outside the box.
No, I understand that, but yes, that could also affect the Court of Appeal. So, but there are 3 questions I would like to ask you, because I've also been thinking over my ashwenge on this case, and to try and make sure I got them clear, I typed them out. Because you're saying that Section 32K, 42K should be an alternate route to vindicate the constitutional right to liberty, engaged by the entitlement of a defendant to be credited with time served towards his sentence. There are 3 questions. 1, as there's no exercise of discretion, assuming the information is right, involving crediting time served, it's just an arithmetic calculation. Should it not be the primary duty of the first instance sentencing court to uphold the constitutional right to liberty by applying the appropriate credit, bearing in mind as well that the delay involved in engaging the appellate process could itself lead to a breach? That's one.
That is so.
Two,
my lord.
Conversely, is it that the Section 32 certificates, 42 certificates, are really meant to address situations where the existence of the mandatory minimum has not, in the mind of the trial judge, permitted an exercise of his or her discretion to adequately balance the circumstance of the particular offender and the offense, and or the relevant aggravating and mitigating factors, thus leading to an injustice? That view of those factors being discretionary, the Court of Appeal could agree or disagree. But in respect of the time served, there really is no discretion. It is to be credited. Against
Once the information is correct.
So against the background of those two considerations, given the move towards criminal case management, and you know that there are new rules that are almost promulgated, where we must deal with cases justly, efficiently, and in a timely manner. There are implications not just for the particular case, but for the system as a whole.
The administration of justice.
So should we require the engagement of an appellate process to vindicate a constitutional right in that context?
You know, my lord, I think perhaps I am not being clear. I concur with everything that you have just said.
Yes.
But perhaps I'm overthinking it, because ultimately it is for the sentencing judge on the ground, looking at all the circumstances.
I'm sorry, madam. Yes, thanks.
It is ultimately for the sentencing judge.
Yeah, but the sentencing judge is expected to be assisted by both the prosecution and the defense.
That is so.
So the prosecution represents the state. The state would be the side that is supposed to have all material information. So this talk about corruption is passing over my poor little
my lady, may I just simply say, I'm a humble prosecutor still in the trenches.
And I'm the
And I
humble
have
judge.
seen, well, when you're a judge, sometimes you levitate up there. But
Yes.
being a humble prosecutor in the trenches, I've seen a lot
But
as a representative of the state.
But you have to ensure that the once again, remember what the law says. It's from the date of arrest, and the first date you're taken into custody on account of allegedly committing this offense. And therefore you start count from there. Who would have access to that information? But the Crown through the police. If your police don't give you the proper information, that cannot be laid at the feet of the accused.
I can assure
understanding that. One second.
Yes.
And just to say this, we are not acting as if there are no exceptions to the rule against crediting. The case law has established that.
Well, I'm happy to hear that.
And it is predicated on an inquiry being conducted as to not only how long you have been in custody, but what accounts for you being in custody for so long.
Yes.
If it is the accused's fault, the Crown is expected to have the information to say to the court after the plea of mitigation is made that half of the time was due to his lawyer being absent, or he failed to whatever.
Or he was serving another sentence.
You have to balance as to and that is what the law, the Romeo da Costa Hall says it, that there are about 3 exceptions, and we can't close the door on others. So it's not cast in stone that we just get up and credit. There must be an inquiry into how long and why.
My lady President, I am very happy to hear you reiterate this position. And I can tell you from my stance, this is one of the reasons why over the last few years I have pushed for Crown Counsel to be able to, in a sentencing hearing, to address the court.
But the Court of Appeal has laid that down as practice long time, even to invite you here. Because back in the days when I used to be in the trenches, as you call them, although I'm not out of them, the court used to not trouble prosecuting counsel about sentence.
And my lady,
there's a
and I will
shift.
say this, the system is fair, but sometimes that doesn't happen all the time. My lady, I can tell you that.
Okay.
It does not happen all the time. It doesn't
I know
happen
in
all
this
the time.
case, at the time it was dealt with in 2016, we were not there yet, and the Crown didn't even have a right of appeal. But now
That
the
is
Crown
so.
has a right of appeal. You're a proper party to any sentencing hearing.
That is so. That is so,
on that
lady.
ground, that is where you should come in and stand up there and say, he should not be credited for 5 years because of so-and-so. If the judge ignores you, then that's a ground of appeal for you and
That
a point
is so,
of law.
lady. And coming from this appeal, we certainly will be reiterating that protocol, which we have already put in place.
I noticed your instructing counsel wanted to say something.
May I have a moment, my lady?
Having concurred with Justice Fraser, with Mr. Fraser. I was going to say Mr. Fraser, then I changed. I put Mr.
We know that the patron saint of Jamaica is Anansi, so she must guard against Anansi, and make sure that the proper.
Madam DPP, I'm sorry. Yes.
I'm very proud of having come from being Crown Counsel.
No,
No
I'm not
problem,
used to
my
saying
lady.
Madam DPP in these parts. Yes.
My Lady President, I'm really very happy for this interchange, because what it really means is that certainly Crown Counsel will have to be even more prepared in the submissions that they make, in making sure that the sources of information, that it is sterling, it is genuine, and it has been fact-checked to make sure. I think coming from this, as I'm looking as a manager, that is what it will mean. Although we keep very detailed notes in our minute sheets, but it will mean coming from the ruling that we agree will come from this court on the whole issue of it being a breach of the constitutional right, and that the pretrial remand, that the credit must be given. We will have to make sure that the sources of information are pristine.
And if he gets bail,
Yes.
that must be reflected.
Yes.
Off bail, although off bail doesn't mean
Yes.
you're out yet. But these are the things that you have to be. This is record keeping at its best, because the court needs to know when a person raises the issue that he or she has been in custody, the court investigation is triggered, must be triggered.
And it would also mean, as I was just explaining to my colleagues, that the advocacy of the prosecutor in respect of the court will also have to be robust within the context of us as ministers of justice wanting to make sure that the result is just.
May I tell you?
Yes.
That there are some jurisdictions where, even in the UK, even if you're on bail and you're put on curfew, once your liberty is restrained, even on bail, that is given a deduction, but that is statutory.
Well, that is statutory.
So I'm just showing you how far courts have gone to protect this basic right.
Well, you know, my lady, I was saying to my learned friends, that the whole world now knows my age, but 40 years, when one looks at the principle of fairness as the overriding objective, and we all know the Queen again sang, which allows illegally obtained evidence, and we see now that notwithstanding that it's almost old law, that once the whole issue of fairness has evolved to the extent that once there is unfairness, then notwithstanding what Sang says, the evidence cannot be admitted. And this is where we are in terms of how far fairness to the accused is the overriding objective. So I feel privileged that I am here seeing the evolution of this matter before this court. So I think we can leave that, and I believe that what we had to say in our further submissions, I trust that it was quite clear, my lady. And let me move to paragraph 7, which reiterates what we have been saying. The failure of the Court of Appeal, certainly in the Duncan's case, to consider the exercise of its discretion conferred by Section 49(1) and its decision to give a loss of time discretion in relation to the appellants had a particularly severe effect on the rights of the accused to liberty and security of the person. That is where I got the liberty and security, and I quite liked it, actually. Liberty and security from the Duncan's case. A core interest of individuals protected by the Constitution. I'm just commending this part of Duncan. Paragraph 7 of our further submissions, because we found this paragraph from the Duncan's case quite attractive. And a core interest of individuals protected by the Constitution. They were penalized by imposition of an additional period of imprisonment for bringing proper and legitimate appeals, which in context amounted to a form of arbitrary detention without justification. By failing to consider the exercise of its discretion under Section 49(1), the Court of Appeal treated the provision as though the general rule was a blanket requirement to give loss of time directions in every case, and thereby prevent time in prison awaiting the hearing of an appeal from counting towards sentence. We reiterate, we can go now directly to the cases. I'm at paragraph 9.
Sorry, that is what the end of this insert, how it aligns itself with this case, because
that
this
is
was
so.
The loss of time in
That
prison
is so.
awaiting the hearing of the appeal.
And this is why, my lady president, we found that area so attractive, which is why we have highlighted it.
Time stopped running for them, but it was real time nevertheless.
That is so. That is indeed so, my lady president. In paragraph 9, we would say that if this court is of the view that a recalculation of sentence does not apply in the circumstances, then the prescribed minimum penalty would be manifestly excessive. I would say it would be unjust, since the sentencing judge did not take into account the time the appellant spent on remand. The onus would have been on the sentencing judge in the circumstances. It is our view to issue a certificate under Section 42K of the Criminal Justice Administration Act to prevent the violation of the constitutional right to liberty. Of course, we are looking back. We are looking back at it.
But the judge, to be fair to him, at the time, 2016, when he sentenced this Mr. Moore, he didn't have the benefit of Misha Clement because that didn't come to the jurisdiction yet to embrace Kalachan, and that is why I know, because the man's appeal is still before us. We now have to look at the law as it is now. So we don't want anyone to think that the trial judge did not do what he ought to have done according to law. But we had the old common law rule anyway.
We had the old common law rule
that you give people, the practice would be that you give some deduction, but not necessarily the full credit. So Kalachan really is just saying how much we should give, but we usually have that in our jurisdiction to give something. But he would have found anyway that he had no right to give anything.
Well, that is so, because in the face of the mandatory minimum, let me put it this way, there was no vehicle outside of 42K that would have provided a legal construct from which he could have drawn to make the sentence more unjust by taking account.
Yes.
It would have had to go to the Court of Appeal for the Court of Appeal to, looking at the reasons, agree that the pre-trial remand figure should have been taken into account, and then the Court of Appeal would have been able to make the adjustment.
So it ended up getting more time, Mr. Moore.
Well, that is so. Although, as we did say, that it was not manifestly excessive, because we have case law from this court where 18 years is deemed to be a proportionate sentence for this type of scenario, this type of offense. And this is why, my Lord Fraser, I am focusing on the word unjust, because it fits very neatly the scenario here into the concept of being unjust. At paragraph, so we still, notwithstanding, we still accept that the learned sentencing judge erred when he failed to issue a certificate. It would have been appropriate so to do, given the circumstances. Paragraph 11, the Crown submits that the appellant's claim for constitutional redress for deprivation of his liberty would have been distinct from an appeal that the sentence is manifestly excessive. And this court, in the Queen against Omar Anderson, I believe it was one of the first cases where this court, how should I put it, implemented the range of remedies from Melanie Tapper et al. And happily in this case, as I recall, a declaration was made of the constitutional breach in respect of delay, but the conviction and sentence was still upheld. So it is our submission that coming from this line of cases, that this Court of Appeal certainly, or the court, would have the jurisdiction to address what would be in effect a constitutional claim once the issue has arisen, as it has in this case. And we now refer to Evan Jack and the Queen. And I must confess, I have coined the phrase. One looks at the three main remedies available coming from Melanie Tapper's case. And Evan Jack's case represents what I would call the nuclear option being used, because in Evan Jack's case, the conviction in respect of the delay and the fact that the transcript, as I recall it, the full transcript was not available and some considerable time had passed, and the Court of Appeal thought it would have been just to quash the conviction and set aside the sentence. And in fact, I think the Crown would have had to concede that that would have been the most just solution, but I refer to it as the nuclear option. So in Evan Jack and the Queen, my Lady President, my Lords and my Ladies, which is a 2021 JMCA Crim 31, at paragraph 44, it was stated that redress for breaches of constitutional rights may take a number of forms, ranging from a public acknowledgement of the breach to a quashing of the conviction. Public acknowledgement of the breach, reduction of the sentences, and quashing of the convictions are remedies that this court can grant in appropriate circumstances, without the applicants having to apply to the Supreme Court pursuant to Section 19 of the Constitution. And this court has previously granted redress for delays in the hearing of appeals, and it reduced the respective sentences in Tapper and the DPP, in Tekla Simpson.
Miss Llewellyn,
yes.
I think we have read this. You can take it as read. Sorry to
very well.
But because our view is, this is not the type of case that we're looking at. We're looking at whether there's a constitutional claim to deprivation of liberty, and whether the one that we usually do fear, the delay, which results in a right, and what the remedy should be. If we go back to even, and you have it right, correct, when you say, even outside of the constitutional rights of this appellant, the Privy Council didn't even touch Kalachan on constitutional rights, you know. They say it's just the basic and fundamental right to liberty, which of course we have embodied in our constitution. So we're not looking at this as a constitutional claim. What we're looking at is whether we should give effect to recognize the man's right to in the interest of justice and as well as in the interest of the rights guaranteed to him. So we understand the jurisprudence coming out of these lines of
Well, it's just by parity of reasoning. In terms of just to re-emphasize where the court has evolved in respect of the remedies that are available for breaches of the constitutional right. This is why we have put it there. So in the same way, by parity of reasoning, that in that arena that deals with delays, this court has been prepared to adopt 3 particular avenues depending on the justice of the entire situation. This is why we have put that there. So in the same way that the court has been prepared to do that as it relates to delay, we are inviting the court, or we are agreeing that because there is a breach of the constitutional right of Mr. Moore to his liberty, this court gives the evolution of the court in this whole recognition of the critical importance of the remedies that not may be available. I am going to go as far as to say that must be available to address the breach of that constitutional right. By parity of reasoning, one would understand that the court could also adopt this approach.
Or any miscarriage of justice.
That is
what
so.
We're here for.
Once it is underpinned by that legal construct of breach of the constitutional right. Because I'm always mindful that to continue to inspire and maintain the confidence of the public in the administration of justice, the law must be certain, and the threshold of the exercise and application of the law must remain very consistent. It's high. So that the members of the public can understand and have the confidence.
It should jump out at anyone, even if you're not schooled in law, that when the appeal court says your conviction is quashed and your sentence is set aside. The sentence is set aside, but what happened? You were in prison and this person was at the GP awaiting his appeal. So when you say the sentence set aside, he served time in prison. So that sentence, as the Canadians say, that period is dead period because the sentence is set aside. So it becomes real time because he served some time. In pursuant to the sentence, but remember, our law is that once you appeal, time stops running on the record. So even though time stops running, you're in there. And that is why when we uphold it, we cause it to run from the date it was imposed. So that time awaiting appeal is not lost for the benefit of the individual.
But
so that is basically where this particular case might be a bit different from the ones that we have been dealing with over time.
That is so, my Lady President. But I was really struck by what was said in Duncan. And if I may say this on behalf of the poor judge in this matter, the system, as governed by the rule of law and as presently constituted, is fair, but it is not infallible. And it is human to err, even if you are a judge. And again, I come in peace when I say that, even when you are a judge.
Madam
Certainly
DPP.
I know, as a DPP or a prosecutor,
yes,
it is human to err. But what is most important is that the checks and balances in the system are of such that it can be picked up and dealt with, and justice is achieved at the end of the day. So those are
Yes,
our
before
submissions.
you complete, Madam DPP,
Yes,
just
my
wanted
lady.
to ask you to look at the index to judges bundle filed by the applicant on the 12th of December. 12th of December, and tab 2. Tab 2. No, tab 2 is original supplementary grounds and skeleton arguments. Are you seeing it? This is what the applicant, bundle 1, tab 2, and the final page in tab 2, the final page in those submissions, where the applicant,
Paragraph 6, my lady.
paragraph 6, and the final paragraph. So this is page 5, and it said, our submissions are critical in the context of the very practical issue raised by the applicant with us, which is that had he been serving his sentence from the time he was in custody, he would have completed that sentence relating to the illegal possession of firearm and would now be approaching the time to apply for parole with the sentence for wounding with intent. Just asking whether that would be your understanding also.
May I have a moment, my lady? What they have is 3 years. They have 3 years. Yeah. 2 years and 9 months. My lady president, my lady Foster Pusey, could I just have a moment? Because we're just double checking something.
Tell her that you calculated, Nicole. Tell her that take out our mission. We do have time.
Madam DPP, perhaps a little later you could give us your view.
Perhaps we could
yes,
just
and
put
you could
something
take
in writing.
you and your
we're gonna
team
have
could
to,
look at it.
because we have to double check the parole
Our
act.
computation is 2/3 usually it is.
It is 2/3.
So if you have it on 15, it would be 10 out of 15.
That is so.
But if it is reduced to 12 point something, it would be 8 years, and he's now doing almost 9. So he would pass his time for release if the time served is to be credited.
That is so, my lady president.
But I mean, you can double check that. But
We
that
will
is
just double
our
check that.
understanding, yeah.
Because we were thinking that that may be so, but we'd like to double check.
Yeah, no problem with that. That you have a
Very
right
well.
so to do. It was raised by Mr. Fletcher and Mr. Russell, but they didn't expand on it to show us in numerical value. So, Madam DPP, that sounds like you're at the end
That
now.
is so, and I mean, we
Yes,
just
and
would
we have to hear
indicate
from
I've
the-
already conceded.
You have, thanks.
And it is quite clear that based on the fact that his constitutional rights to liberty would have been in effect violated by the pretrial remand. Time not being credited, certainly this court would then be obliged to make the necessary, set aside the sentence and make the necessary adjustment. May it please you, my Lady President, may it please you, my lords and my ladies. And may I also just right now thank my learned colleagues also for their research and their assistance at very short notice in this matter. May it please you.
Thank you, Madam. Mr. Foreman, you're ready for the boxing? I'm trying to be like Justice Fraser.
Good morning, Madam President, my ladies and my lordships. For the purposes of these submissions, I will be relying primarily on Volume 4, which is the submissions and list of authorities of the Attorney General's chambers. We rely on those submissions in their entirety, save that on issue 2, we have also had some benefit from the Duncan case, and I will be framing the submission in the light of the learning that we see extracted from that particular authority. Well, we had broken down the issues that we saw in 2 respects. The first one, whether credit can be given in relation to a mandatory minimum, and then secondly, whether this particular claimant, this particular applicant should be credited. So it's in relation to the second of the 2 issues that we characterized, where the Duncan case will be added. Yes, as a sub-issue. Yes, that's page 3 of the written submissions of the Attorney General's chambers. This is at the top of page 3. Right. So you're going to zero in on 2? No, in relation to the Duncan case. Right. Very well. Thank you. You're welcome. I begin by noting that the appellant's submissions say that time spent on remand must be declared a constitutional right, which must be accorded to the convicted person. And additionally, having regard to the way in which proceedings have gone since this hearing began, it's also my understanding that one of the core issues that the court is seeking to address is whether the right to liberty in the Constitution includes a right of the convicted person to be credited with time spent in pre-sentence custody. Our submissions in brief outline are the following. The text of the right to liberty in the Constitution does not speak to...
Mr. Foreman, are you reading from your submissions, or are we to write what you're... Have you adjusted?
This is my speaking notes.
Yeah, but we have to write then, because
Very
we don't have copies of your speaking notes. It would have been helpful if we could get copies, but at least we wouldn't have to write.
Okay.
Because what you're saying now is not in your written submission, right. So you have to help us by going a bit slower, please.
Understood. I will do so.
Thank you. So you're saying now that...
the submissions in outline will be the following.
Or you could give us that after too. That we don't have to write everything.
With some refinement.
Yeah.
Right.
Yes.
The first is that the text of the Constitution does not expressly include a right to an entitlement to credit for time spent in pre-sentence custody. The right to liberty, referenced in section 13(3)(a), is not engaged when a convicted person is not credited for time spent because section 13(3)(a), in respect of crediting of time.
He's going to have to give us this. Yes. But basic points.
Yes.
Not credited for...
Because not credited in respect of time spent in pre-sentence custody.
Yes.
because 13.3a expressly states a limitation to the right to liberty where that liberty is deprived in execution of the sentence of a court in respect of a criminal offense. And Mr. Moore was sentenced subsequent to a conviction. Secondly, the right to liberty in section 14 of the Constitution or of the Charter, which we will say is the most appropriate provision for examination of this issue, sets out the lawful bases on which a person may be detained and those bases are satisfied in this case. A third point in relation to the interpretation of the constitutional right to liberty relates to the cases that have been cited in support of the application.
1 second, Mr. Foreman, just a minute, because you're highlighting those provisions that relate to justify, where you'd rely on to keep in custody the person in custody. But yet there's the other provision of the right to bail, because if you're saying it was engaged, just to highlight that the Constitution tries to balance the rights having regard to the right to liberty. So there's also a right to bail within the Constitution for those who, which section, the last section you cite about reasonable, oh, you didn't know.
That's section 14.
14, right.
And when I go on, I'll look at 14.1b and 14.1f.
Okay, so just to show you that the Constitution, even though you can do that, and we won't have to go to the facts of this case because you know this one. All right, just to appreciate what you're saying.
Understood, thank you.
All right, the case law now.
And the cases we will submit do not say that there is a constitutional right to credit for pre-sentence detention. We say that these cases stand for the proposition that when a court is given discretion, whether at common law or under statute, in respect of sentencing, that discretion should be exercised to give credit for pre-sentence custody or pre-sentence detention. So that's our first point regarding the interpretation of the right. The second element of our submissions is related to the point I just referenced. And it is to say that in our submission, the cases cited rest on the constitutional theory that limitations on rights should be given a narrow construction or a narrow interpretation, so as to give the citizen the full benefit of the right. The final aspect of the submission will be to say that in the context of Jamaica's legal provisions, a failure to issue a Section 42K certificate, as this court has interpreted those provisions and the circumstances in which those provisions ought to be applied, might deprive a person sentenced to a mandatory minimum of a fair procedure established by law, the law here being both legislation and the interpretation of this court. And that in that specific circumstance, the Section 14 right to liberty is engaged and might be breached. And as I said earlier, in that respect, the Duncan case we found was helpful, because it also addressed a situation in which an approach that ought to have been taken was not in fact taken, and the failure to do so resulted in the appellants being deprived of their liberty when they should not have been deprived of that liberty. Now, I would like to, I'm structuring the submissions in the following way. The first thing I'd like to do is to remind the court of the approaches to interpreting the Constitution. The second will be to look at the charter provisions. Thirdly, I will say why in our submission the cited cases do not, read on their own, establish the proposition that the entitlement to credit for pre-sentence custody is a constitutional right, as opposed to a duty on the court in exercising its discretion to give that credit. So if I may begin, the first point of interpretation I'd like to raise is that the Charter itself has specified limitations, and that there must be a determination of the scope of those rights having regard to the language used in the Charter itself. In this respect...
Mr. Foreman,
yes.
Just need some assistance. We have had a number of exchanges on what Section 42K really covers in our view. And, you know, the learned president has indicated, for example, that it really deals with the sentence itself. So, for example, supposing a person committed an offense of wounding with intent and with a firearm, I suppose that I think that is where the mandatory minimum comes in. But when the judge looks at the circumstances, the judge feels, yes, this is what you did, but, you know, I really still feel that 15 would be too high and would be harsh in these circumstances. So it is the circumstances in which the offense was committed and the, as my sister is indicating, the circumstances of the offender that would make one believe that this 15 years would be too high. That is the circumstance, and when we interpret 42K, that is our understanding. So we don't understand that 42K, at least so far, would be related to giving credit. So for pre-sentence remand. So I think that at some stage you would need to assist us with how you interpret 42K, because that is the understanding that most of us have as to how 42K is to be interpreted. So I think you should assist us with that before you move on to how you feel 42K applies in these circumstances.
Thank you for that question, my lady. In brief, our understanding of this court's jurisprudence in relation to 42K is that it is the provision that allows the convicted person's mandatory minimum sentence to be reduced below the mandatory minimum. In that respect, paragraphs 37...
I think that has been said in some judgments. There's no denial of that. And that is why we're here as a body of 9 to review whether or not that should be the approach we take going forward. Because we have to make a clear distinction, it would seem to me, between our powers in regards to the sentence itself, which is quite clear. And remember, 42K is incorporated into judgment by the amendment that was passed at that time. The sentence itself, and we are clear as to what should be done to arrive at an appropriate sentence. Having arrived at the appropriate sentence, the question is separate whether or not the time spent in custody should be factored, how it should be factored.
Yes.
So it's not a matter, and I think this is a problem that when Ms. Llewellyn mentioned the public perception, when we do it, people say we're reducing the man's sentence. We have not. We have acknowledged, and that's why I asked Mr. Fletcher at the start whether he's saying that the sentence was excessive. And he said he's not. So based on that, we're not reducing the sentence. We're confirming that this is a sentence. But we're saying that it is to be served to account for the period he has already spent in custody. So he's now to serve the remainder. So we need to be clear as to what it is we're actually trying to determine here. Because you're quite right. We have several authorities which may have said, which did say, not me, did say that 42K is the only way that we could deal with it. That is why as a body of 9, based on our previous pronouncements, we have to determine the way forward.
Whether we, right.
Thank you.
So we don't want you to feel that you're wrong. You're correct. And that's why we're here, and that's the first day. But what we have to, just to add to what my sisters have said, is that because the court recognizes the dilemma between the minimum and the time served, the court utilized that tool of 42K to give the relief. So it's not that we might not have recognized that 42K is not dealing with sentence, but in order to deal with the justice of what is before us, we say, since we have a certificate that says the sentence itself might be disproportionate and unjust, we look at everything, including whether time was given. So we're not saying you're incorrect at all. You're so correct. And why we're here is to determine whether that approach should continue, or the court says where the man is to be, or the woman is to be credited, and the credit is not given, do we give it regardless of whether a certificate was issued? In any circumstance, even including where the mandatory minimum is applicable. So we don't want you to believe that you're at all wrong. You're looking at the jurisprudence that has developed to date. And the Court of Appeal had incorporated 42K in the question of whether we should go on the minimum. So we are here to determine whether that should continue, or do we say depart from that? Right. So that is why we're sitting as a full court.
Understood.
So,
right.
So we thank you for your assistance on that. And I love that you recognize that when it is not issued, it engages 14 too, especially when the person is being held on reasonable suspicion, because The Constitution gives them the presumption of innocence as well. So you said it is engaged, and therefore then the court's approach to fixing it, we have utilized 42K to fix it. So I don't want anybody to think that you are Miss Llewellyn, the DPP are going off tangent with 42K, because our case is incorporated 42K. But it's just that we need assistance now to look at it afresh.
Yes.
With your help from the Attorney General's Department.
Mr. Foreman, is it that I'm just trying to understand what you are saying. You're saying that we shouldn't engage it as a constitutional right as at the beginning here now, but it should only be considered as a constitutional issue if the trial judge fails to engage it at the time of sentencing. I'm just trying to understand what you're saying. Is that what you're saying?
May I refine it in light of how you framed it, my lady?
Yes.
The first point I am attempting to make is that the right to liberty as framed in the Constitution does not expressly include a right to being credited for pre-sentence detention. So the engagement of constitutional principle would not arise at that stage.
Yes, that's what he's saying.
What I do say is that if there is a discretion, or if the legal system provides a mechanism that would have the effect of reducing, limiting the extent to which an individual's liberty will be deprived, even if where that deprivation is pursuant to one of the constitutionally permitted grounds of deprivation. The principle of some authorities refer to it as conform interpretation. Giving a purposive interpretation to the right to liberty means that the discretion must be exercised in a way that confers the benefit on the individual. So if it's if we're dealing with purely with things at the level of the common law, if there are two possible approaches, the court should adopt the common law in a way that furthers the constitutional interest at play.
Right.
If you're dealing with a statute, and the statute is ambiguous, may be read in several different ways, in the circumstances of a 42K context where the language is framed in a very wide way so as to engage the discretion of the court in determining when appropriate circumstances exist for that particular constitutional provision to be exercised, the court should exercise that discretion in a way that would afford the individual more liberty rather than less, even if that less is expressly recognized in the Constitution itself.
And we must always read if there is a provision, and we believe that, as you say, constricts the right. As far as I know, you give that interpretation, as you are saying, that broaden the rights and avoid any conflict with the person's constitutional rights. So that is why the court had used this device of Section 42K to give effect to that. But when the certificate is not issued, that is where the question arises.
Yes, and as I have said, I've explained my view on that.
So I think we get that.
Is the health break?
No, you're at a convenient point?
I think so. May I just make one point just in response to the last question that you had put to me? I acknowledge that if this court says that the sentence and credit for time spent in pretrial custody are separate concepts, then it would flow that time must be credited for the reasons I've just given, maximizing the right to liberty by reading the limitations in a narrow way. I do think I am constrained to highlight as no doubt your ladyship, your lordships are aware, that some of your jurisprudence does not treat the sentence and the credits separately, right? Right? So I accept that if you interpret it in that way, certain conclusions necessarily follow, but you do have in the way to indicate how you treat with the existing jurisprudence.
That's what we expect this case to do with the 9 of us, to lay down what should obtain from now on and our approach. Because there are cases that declare the sentence. Like you'll say, the sentence is 15 years. But 2 years is credited for time served, and the third part would therefore say there is to serve 13 years. So it is clear that the sentence is and shall remain 15, but is to only serve 13 out of it, because we deduct, well, not only, he should serve the remainder because 2 years deducted. So that is the approach that what we are grappling with, is the proper approach to give effect to the sentence itself, and that right that we figure is engaged and should be vindicated. So we got you,
Right.
and you are not off, as I said, because that is our jurisprudence to date. It needs for us to refine our approach. So anything arising now. So we're going to take that break now and return 10 minutes time. Give us 47. We'll come back at 10:50.
10 more?
10:50. 3 minutes additional. So you please rise and take your stretches. Ready? Thank you.
Please sit.
Yes, Mr. Foreman.
Yes, thank you. Right. Madam President, before we took the break, I was going to take the court through the relevant principles of constitutional interpretation as we see them as being relevant in the context of this case. These principles are, of course, very well known to your leaderships, your lordships. I therefore don't need to take too much time. They are set out in paragraphs 16
You can leave this to us.
to 27 of our submissions.
Right.
The one principle I would just like to just make a specific reference to is the concept of lex specialis, the statutory principle of lex specialis being applicable in the constitutional context. That is to say, where the Constitution deals specifically with certain matters, more general provisions do not take precedence over those specific provisions. And authority for that proposition is found in the Chantal Day case from the Privy Council. In our volume 4, the relevant pages are 483 to 484. The numbering is at the top right-hand corner. Sorry, the case is Chantal Day. So the case starts at page 467 of volume 4.
Understand where this fits in about where you have the special principle and the general in relation to what? Just to get my head in.
Sorry, I'm still addressing the constitutional basis for finding an entitlement to pre-sentence custody in the Constitution itself.
I see.
Right? And the point in respect of the lex specialis is that the Jamaican Charter has, well, at least two main liberty provisions. Section 13.3a and Section 14. Section 14 read in conjunction with Section 13.3p. Okay? Section 13.3a, which I think is adopted from the Canadian Charter, speaks to the right to life, liberty, security of the person, all of which are subject to the execution of a sentence of the court, etc. And Section 14, which also featured in the pre-charter constitution, the 1962 provision, and is the provision that you see in the rest of the region except for Trinidad and Tobago, concerns itself specifically with the right to liberty in the context of detention.
Right. And before trial, that is the one.
Right.
Before conviction.
Right.
That's the one we're dealing with now.
Right. And as the court is well aware, those circumstances include pursuant to conviction and pursuant to reasonable suspicion of having committed an offense.
Right.
So the basic submission on this point is that the analysis of the right to liberty in the context of this case, should properly center on the section 14 right to liberty. I acknowledge thus far most of the discussion has been centered around 13.3.3a. And as we've also said, we think 13.3a is also not engaged in and of itself because the appellant was convicted. So in relation to section 14, a difficulty might arise in saying that on the one hand, it is constitutionally permissible to deprive someone of...
I'm so sorry, Mr.
Yes.
Foreman, but wouldn't you say that he was convicted at a particular stage? Because there was a stage where the conviction was set aside.
Yes, there was a stage where the conviction was set aside. My understanding of the jurisprudence is that even where a conviction is later set aside, that specific constitutional provision that allows detention pursuant to the order of a court upon conviction has not been breached.
No, it's not breached.
Whatever other remedies might be available, that specific section is not breached. And my submissions at this point is solely concerned with determining the content of the right.
Yes.
So the initial conviction we submit not unconstitutional because it was pursuant to the sentence of a court,
Yes.
and neither the subsequent conviction, notwithstanding the lack of credit for the time spent in detention prior to the 2016 conviction.
Right. Nobody
So
says
we made those points in terms of how the text of the Constitution should be read and understood. And I will go further to say that reading finds support in the judgment, the partially dissenting judgment of Justice Witt in the Romeo da Costa Hall case. I think it's appropriate for me to just go there.
It's all right.
Yes, I rely on volume 1, the index to Judges Bundle. It's found at tab 7.
Now to go to Hall. You were speaking about lex specialis. So
right.
you're leaving that for now to go to that.
I assume that the point was made on the lex specialis point. If your ladyship would want me to just take you through the specific aspects of...
No, I was wondering if you're leaving that to go to this now.
Yes, I'm leaving that to go to this because I
didn't know if you had completed your submissions on that before going to this because of the questions. I'm just asking.
Yes, I think I can move on.
All right. Thank you so much.
Yes, thank you.
I think to be fair to you, have it spelled out at paragraphs 23, 24 in your written submissions. So
yes, in some detail.
we could rely on that.
Yes.
So you're going into Romeo da Costa Hall, Justice Witt?
Yes, no, I am...
Judgment?
I'm
Tab 7.
supplementing... Sorry, I had a loose leaf copy.
It's in tab, is Romeo da Costa Hall?
Yes.
Tab,
Volume 1 of
Tab 7.
the... Tab 7? Tab 7. Oh boy. Yeah, but part of mine was missing. That's why I have to print another copy. So the Justice Witt's approach to the judgment took into account the... Is this mine? Oh, okay. Yes, there we go. Thank you. Yes. Justice Witt, as he's wont to do, try to understand the legal, intellectual, philosophical basis in which the consideration of giving credit for time spent on remand ought to be based. And he engages in that exploration beginning at paragraph 37. So he says, and I only need the first sentence there, another important point I would like to comment on is the legal basis for the adoption of this approach. The approach meaning the Kalachand, what I would say is the common law approach to giving full credit for time spent in pre-sentence custody. And I'll just go to paragraph 38, because at that paragraph, he begins by looking at the Constitution of Barbados. And the relevant provision in the Barbados context is the equivalent of our Section 14. Right? I think it's framed as personal liberty and not freedom of the person. But that's not a significant difference for our purposes. He says at 38, it would seem that the Constitution of Barbados does not provide a clear legal basis for giving full credit for time spent in custody. The Constitution, however, does guarantee both the fundamental right to liberty, Section 13, and presumption of innocence, Section 18(2)(a). It is also true that while the former provision does state that, quote, no person shall be deprived of his personal liberty, it continues, however, by saying, save as may be authorized by law. This expression particularly applies to the situation where a person is incarcerated, quote, in execution of a sentence of a court in respect of a criminal offense of which he has been convicted. But it equally includes the situation where a person is held on remand upon reasonable suspicion of his having committed a criminal offense. Oh, okay, it was me alone. All right, I shall print some more copies. May I direct it to volume 3, tab E, the respondent's volume, tab E. All right, grateful to my fellow government lawyers.
Thank you.
Right. Yes. And I thank my colleague government lawyers from from the DPP's office. Yes, so I had started at 30.
It sounds like you belong there.
Well,
DPP.
So yes.
Yes, 39. So we're at 39 now?
Yes, so I was at the top
Yes.
of that page. Yes. Yeah, I know. But let me try to skip that. Yes. Yes. So just to go back to the sentence, but it equally includes the situation where a person is held on remand, quote, upon reasonable suspicion of his having committed a criminal offense under the law of Barbados, even though, quote, every person who is charged with a criminal offense shall be presumed to be innocent until he is proved or has pleaded guilty. And all of those provisions exist in Section 14 of Jamaica's Constitution as well. So at paragraph 39, Justice Witt says, the Constitution of Barbados does not mention, nor does it imply, a clear obligation for the courts when deciding on the sentence of the prisoner to give credit for time spent in custody. However, under that supreme law, all institutions, the courts included, are duty-bound to act rationally, reasonably, and fairly, in which context the two provisions do seem to have some relevance. Now at 40, he indicates what, in his view, is the legal basis for giving credit. I may return to this later, but the point only make is that in the paragraphs where he analyzes the constitutional basis, he doesn't come to the conclusion that the liberty provisions themselves take him to the point where he can say this is the legal basis for the conclusion.
Sorry, before you go on, just what do you make of the Privy Council doing Kalachan saying it is just a matter of basic liberty?
Right.
Because
Yes.
the two of them, that is what the Privy Council said. So
Yes.
what is basic liberty?
Yes.
What they didn't say, because the Mauritius Constitution was not in effect. So I'm just asking how that,
Yes.
or you...
Madam President, in
None
my
of them delve into
yes.
Constitution except some other cases develop it along that line. But these two did not go deep. But that is what, I'm just saying here, he didn't say basic liberty. I'm just drawing it to the fact that the Privy Council had said
Yes.
basic liberty. That's all. Yes.
I say
In Kalachan.
the following in response. One, as I will go on to show, both Kalashand, Da Costa Hall, Misha Clement, the courts in all of these cases are reasoning in the context of either a statutory discretion to give credit in all circumstances, or in a context where there is no statutory minimum specified by statute. In other words, all of them concern situations where the court has full discretion in determining the bases on which credit should be granted or not. So that in
I'm just trying
Kalachan,
to understand what you're saying, because earlier, before we left, you had said that the Old 14 and engagement, because of giving the broader effects, 39, which is saying that it is the Constitution that imposes on us a duty to act rationally, reasonably, and fairly. So I'm just trying to grapple, understand now why you, and then he went on, yes.
yes, he goes on to
No
say.
one is sense of breach is a recognition.
Yes.
Yes.
So I would say that when the Privy Council in Kalachan refers to liberty, it is the court is engaging in the purposive reading of a statute. Right? It is the court there is, and one of the cases I cite affirms that principle. The court is considering the fact that it is in a context where the liberty right is engaged because of a deprivation, and the court is saying, I have a discretion. We, as the judiciary, have to determine how to give credit in a context where this particular statute in Mauritius says that credit may be given for time spent on remand. And the court is saying, in light of the broad approach that we take to interpretation, and having regard to the liberty interest, we are going to say give full credit for time spent unless these circumstances apply. So that's how I read Kalachan and Justice Witt's exposition here in the Romeo Da Costa Hall case. Right? And we say that provides a sort of coherent constitutional basis for the conclusions in these cases.
Yeah.
But was there a legislation in Da Costa Hall?
No, there was not.
Yes.
Right.
Thanks.
So the court, the CCJ did acknowledge that there was no statute in Barbados. I don't know if there is now, but certainly the court was reasoning in the context where there was no issue about a statute either limiting or requiring time to be given, whether in the context of no mandatory minimum or in the context of a mandatory minimum. Which is why I say that these cases, properly understood, stand for the proposition that where a court is given discretion in determining whether to give credit or not, the discretion should be exercised in favor of giving credit so as to maximize the liberty interest. Okay. So that's the... So y- can I end there? Yes, let me let me end there, and let me move to what I say is a surer basis for finding this entitlement, and it derives from a principle that is highlighted in the CCJ case of Trust Company Guyana Limited and the Guyana Securities Council, which is found at, it starts at page 67 of
Mr. Foreman,
Volume 4.
just before you move to that case, I think you were taking us, before the questions were posed, to add paragraph 40 of Hall, where Justice Witt sets out the legal basis for giving full credit before you move on, because I know perhaps we would have moved you from your concentration on the particular point. Yes. And I think at paragraph 40, he's saying that the legal basis for giving full credit is basic fairness, the avoidance of injustice, or formulated more positively, the interest of justice.
Yes. Yes.
So I just don't want you to leave that point hanging in the air, because that is where you started your submission.
Yes.
As to what was the legal basis that Justice Witt gave in his judgment for giving credit for time served in pre-sentence remand. And that's at paragraph 40, correct?
Correct. Thank you, my lady. And I take no issue with what is said.
Thank you.
Is said there. I would connect it to the basic submission that was made in my written submissions, and I continue to make here, which is that certainly in the existing legal arrangements, to include this court's interpretation of the various provisions, there is a basis for that fairness to be afforded to persons, right? If this court takes a different view of the distinction between the sentence and the crediting, I think that objective would still be satisfied on that approach. But it would be a departure from what has been the practice thus far. Okay. So back to my submissions in relation to Trustco Guyana and Guyana Securities Council. So I said it starts at page 67 of volume 4. Here we go. Okay. Now, this was a case involving, it's a statutory interpretation case. The basic issue confronted by the court was whether the appellant should be treated as a public company within the language of the Securities Industry Act of Guyana, and if they were to be so treated as a public company, whether a provision in that legislation requiring those companies to make particular returns applied to that company. On the first issue, the court said yes, the appellant is a public company. And on the second issue, also just relying on the literal rule or the plain meaning rule of interpretation, the court also concluded that the company was required to file the particular returns with the Securities Commission. In approaching that second issue, the court, and I'll begin at paragraph 42 of the judgment. The court goes through the standard process of statutory interpretation. So I'm not going to stop to read these particular paragraphs. But at paragraph 42, the court applies the plain meaning rule of interpretation and says, based on that application, we come to this particular conclusion. And thereafter, the court applies the supplemental tools of interpretation. So at paragraph 43, they rely on the internal context of the statute, other provisions in the statute which affirm or are consistent with the primary interpretation that they have arrived at. At paragraph 44, they reference the principle against absurdity, or which they say would also support the plain interpretation of the provision. And then, importantly for my purposes, at 45, they articulate the presumption in favor of constitutional values. So I'll read that paragraph. In addition, an important principle of statutory interpretation, especially in the context of Commonwealth Caribbean jurisdictions, is that legislation must be interpreted purposively to give effect to fundamental rights and values and constitutional principles contained in Commonwealth Caribbean constitutions. And they reference a Privy Council decision. At 46, in Guyana Sugar Corporation, Inc. and Danesar, Judge of the Caribbean Court of Justice, Witt, agreed with the majority that the respondent's misconduct was such as to amount to good or sufficient cause for the termination of his employment, but disagreed on the interpretation of the relevant legislation. In our view, Witt correctly set forth an important principle of statutory interpretation at paragraph 48 of that decision that, quote, workers in Guyana have a fundamental right to be protected in the law. This means that legislation must be interpreted so as to effectuate the protection it is intended to offer. And then at 47, accordingly, we hold the view that section 56(1) must be interpreted in such a way as to reflect the fundamental rights of non-discrimination and equality before the law of all public companies within the scheme of the Securities Industry Act. So I cite that as one authority that supports the principle of statutory interpretation in the context of a written constitution containing a Bill of Rights, that where a discretion is conferred on a judicial authority, the discretion should be exercised in a way to further the fundamental rights in the particular constitution. And there are other cases where the CCJ has affirmed that particular principle, including in relation to
so just
common
to,
law,
just
common
to
law
help me,
principles.
Mr. Foreman, in the context of this particular case, and you're saying that it would be the interpretation that is to occur is to reflect which fundamental right in this case?
In this case, it would be the right to liberty.
Under what? Under 14?
Yes, the right to liberty under 14.
So you're saying a fundamental right is being engaged
Correct?
in the issue in this case?
Yes. All right?
Okay, just to be clear.
And it is engaged in the context of there also being specific limitations on that right. So to embellish a bit on the paragraphs in this judgment, let me back up a little bit. The fact that the right is engaged doesn't mean that it's breached. All right, so I should perhaps start there.
Seems like you heard me, because I said the same thing.
But yes, right. Right. So the charter itself, does say that rights can be engaged, but
And
they're only
Justice
breached
Witt
in
was
certain
very
contexts.
careful to walk between those raindrops. At no point in his judgment did he say there was a breach at all.
Yes.
But he was able to find a remedy without saying that.
And I agree, my lady, with that interpretation of his decision. And I would say it's the same principle that applies through the cases that have been cited. So yes, the right is engaged because there is a detention. The detention is lawful because it is pursuant to a specific limitation in the Constitution. But that doesn't mean that the person should not be afforded as much of the core rights as is possible within the legal framework, right? And by providing credit where it is possible to do so, the limitation is restricted and the right is maximized. And that, I say, is the... Do I remember?
That is why the question we ask you is framed in the context of recognition. If you notice the question we asked from here, we didn't say whether it was a deprivation, but the argument stemmed from how it unfolded, if it amounts to deprivation, how do you juxtapose that against the law and the remedy? Yeah. But that is what we say, should we give effect to recognize that right to liberty? Because at the end of the day, the Privy Council, even the Guyana case that you mentioned, it not only speaks to the rights, but the values and principles in the Constitution. And that's where Justice Witt started his analysis. He said, the Constitution requires us to be fair and just and reasonable and rational. Yes. So everywhere we turn, there's this inextricable link between the Constitution and our duty to be fair. So my only question is, if at the end of the day we are to give effect to the right, and we don't give it, and it's engaged, it being engaged, we recognize it is engaged, we recognize it should be given effect to, and it is not given, what does that amount to?
If it is not given,
yes,
then there would be a breach. Right? And the Duncan case is useful for that sort
because
of
consideration. Because we appreciate that when the right is engaged, it does not amount to a violation. It's when it is engaged and it is not demonstrably justified in its engagement, then you have the violation. So that's why I said to you, and I think the argument from Ms. Doylein as well is that, is that if it is engaged, you're entitled for it to be recognized on the ground of fairness. It amounts to injustice, and would it mean a deprivation of your right under the Constitution? That's all I want to understand, your argument with the engagement.
It goes further, because if it's engaged, it is recognized that the law must provide an avenue to deal with it once it's engaged. It is at the point when the law fails to provide that avenue, then we start going into the realm of breach.
Exactly.
So
if it's not demonstrably justified, then it's a breach.
My understanding of what you're saying is that in this particular case, and I'm going to start from the beginning because it's very important to start there, that where a person is taken into custody by any form or means of a court order of any kind, whether a conviction or a remand or there is no breach. And the law is clear on that. So therefore, you can't say I've been taken into custody or I was convicted and my case was overturned and I was acquitted and therefore I'm entitled to compensation. The law is very clear on that you are not, because there's no breach. So, and then the law goes on to say where it is that your liberty, for whatever reason, is in jeopardy outside of those particular area, the law must provide an avenue for your liberty to be addressed. Where the law fails to do that, then it is in breach of your fundamental right to liberty under the Constitution. So I come now to your point. Your point seems to be that Section 42K provides that avenue. Yes?
Yes, that's my point, yes.
That is what should be interpreted, you're saying, to give effect to this consideration of the person's right to
Yes.
That's what you're saying.
That's a submission.
If it is not used, then what?
And the question is being asked sort of O'Shea. If it is that section, there's a failure to utilize that avenue, and we're talking about 42K, but we could have been talking about the Bail Act. It's the same principle. Where there's a failure to utilize that avenue, then the judge, you're saying, would have erred, and this court can correct it.
Yes, that's a basic submission.
Yes, and we do, yes. And we...
Right. If it is not corrected, as happened in the Duncan case, and the person is still in custody when they should not have been in custody, then there is no lawful basis for that part of the decision.
Well, let me go on now, because you're focusing on 42K, and the question is why? So you're saying 42K is the avenue. If this court does not utilize 42K as the avenue provided by the law, the legal avenue provided by the law, then the court will be going into the realm of breach of constitutional right at its origin, which we ought not to do, is what you're saying, because there was no breach.
Correct, because there would have been a lawful basis to maximize the liberty interest and minimize the lawful basis for the exception, and that fair procedure, if I can use the language of the chapeau of Section 14, was not afforded to the person by the state, to use the language in Duncan. So that's how I situate the problem that occurred on these facts. And I have been trying to just sort of make clear my basis for the constitutional reasoning, because as I said, what the appellant had put forward was that the Constitution itself, without more, contained that right to pretrial sentencing. Right. So I don't want to be overly pedantic about the point, but my submission is that the approach that I've been trying to articulate is a more coherent approach. It respects the fact that the Constitution does have specific limitations on rights, and it also takes into account both the role of the Parliament by way of statute and the role that the court has played by way of interpreting and applying that statute. Of course, if you depart from the existing way that the approach to considering sentencing has been done, then the issue of having a duty to issue the 42K certificate just solely for the basis of crediting pre-sentence remand would not hereafter arise, right? But I'm saying in the existing legal landscape, there's no constitutional breach in respect of the system as a whole. But in this specific case, there can be a basis for you to conclude that if the crediting is not done by correcting what ought to have been done below, and in understandable circumstances, 2016 was maybe a year or less after the amendment, after Section 42K was introduced into the law, and it has taken a little time for the Court of Appeals jurisprudence to capture and develop the law so as to deal with time spent in pretrial
I think you're
custody.
very clear. I think we get your point.
Okay, so that's the point. On that basis, I think I suppose I can rest. But then if
Sorry, your conclusion was what? I am trying to...
Yes,
we submit, maybe, oh, you did say he may be credited. Okay.
Yes.
But you were going along the CJAA.
Right, so my
which
path
does yes.
is a different path.
Yes, no problem with that.
I eventually get there, but through a different route. Yes.
But because you appreciate that if we don't do it, then that is where we would stand in breach
Yes.
of his rights.
Yes.
This particular
yes.
prisoner's rights.
Yes. And my duty to my client is to avoid.
So is the Constitution and our constitutional duty would have to help him because we don't have the statutory basis. Thank you. Because we're at a convenient point, that's why I was wondering.
Okay.
Are you? You're finished now. You can. You're
essentially,
up?
I mean, unless.
Yes. Mr. Llewellyn, don't instruct the AG.
They listen to you.
That's
sorry. Yeah. So, panel, unless you want to hear me on Duncan,
you're preparing that Duncan is in that those speaking notes. Your submission.
Yes, that's
we could take that because I think you have been very helpful, and we're happy that we called you.
Sorry,
just
one very small point. So you're saying that if the certificate should have been issued but it was not, that's an error, and we should act as if it had been issued.
No.
Okay. Well, let me say that if the crediting is not done when it ought to have been done through the mechanism that I have adverted to, at that point, the breach will arise because the appellant would be in custody longer than he should have been had the crediting been done, right? And to avoid that possibility, because at that stage, we would be hard-pressed to resist a conclusion as to breach in the context of fair procedures, right? So it is in that context that I say the court can act somewhat preemptively, depending on how we calculate the timing and so on, to avoid that constitutional clash.
Sorry. I'm so sorry. Ms. Llewellyn, between now and the time we return, could you just have that figure for us that Justice Foster Please had asked, and we try to posit our own view as to what that is, so we know, because if it is that he's in custody longer than he ought to be in the light of not being given the credit, then that's another issue that the Duncan case would have to deal with. So thank you, Mr. Foreman.
I can sit.
We're ready? Yes, we're going to take that break now and return at 12 o'clock. Then the reply, and I think we are able to wrap up today. Thank you so much. 12 o'clock. Oh, 12:05, I'm sorry. We're doing well. 12:05. Yes?
Please sit.
Thank you. Mr. Stewart, do you have anything to add or subtract? I thought he was finished. Mr. Foreman? Yes,
I'm finished.
I thought he was. That's what I have in my book.
Yes, I am.
Yes.
Yes.
And I told Mr. Stewart to prepare himself. Yeah. He did say he rests on what he has. Unless he... Yes, Mr. Stewart or Mr. Fletcher? I recall Mr. Fletcher saying Mr. Stewart would be the one to reply, but let me go to Mr. Fletcher now.
Madam President, my friend and I have considered and assimilated the submissions made by both the learned director and Mr. Foreman. And I wish to thank them for their contribution to this huge exploration of the issues. At one time I said to myself, it reminded me of the hymn, deep and wide there's a fountain. And it was like that. But having considered and assimilated it, we don't find that there's anything useful we can add or any further analysis of the authorities that have been explored. Except to thank the panel for the nature and extent of their interrogations of us as we put our arguments forward.
Thank you. No, I'm going to. No, it's a... Madam DPP, we had asked you to assist us with the time in relation to the ERD, the early release date, which they always come up here about. So...
May it please you, my Lady President, we went as far as to consult with one of the Deputy Commissioners of Corrections. My learned colleague, Ms. Julianne Edwards, will seek to assist the court on behalf of the Crown.
If it pleases you, my lords and my lady, with respect to the calculation, the 2/3 of 15 years, because our understanding is that the 2/3 would apply to the 15 years,
yes,
since that would be the sentence of the court.
That is so.
And the appellant would be required to serve 10 years, which is right, 2/3 of 15. And then the 2 years and 9 months would be deducted from that figure, which would bring us to 7 years and 3 months. Since the appellant was convicted on the March 2016, 7 years and 3 months from that date would be June 2023.
2023?
Yes, my lady.
Oh, you're correct. Because if we do it the other way and say the sentence ought to have been 12 years and 3 months, then we have to look at 2/3 of 12 years and 3 months. So what it would come out to be?
It would come out to be 8 years and 2 months, which would take us to January of 2024.
2024.
If we do it the other way,
yes,
but what our
so
view,
their way makes it an earlier date for him. 2023.
That is so.
No, I thought it's what they told him from the prison.
No, my lady, we are, well, they told us a 2/3, my lady, but we are thinking that if it is that
based on our understanding and reasoning in terms of the pronounced sentence of the court, the imposed sentence would be the 15 years, then the 2/3 would apply to the 15
No,
years.
yeah, we understand
Yes,
that,
yes,
but if we are saying that it should not have been 15 from over there at all, having credited him after the sentence is announced, we go on, we move on.
Yes.
If we take out the 2 years, as I understand it, we have to say what time he should be serving now. He should be serving the time that he should serve, and that would deduct from the EDR is not our business. We just want to know if the date would have passed on either
The date would have passed,
calculation. But that is all, because that is where the Duncan point would pick in. But it's not for us, but we just want to know to ensure that no one can allege that there's any issue down the road based on what we have.
Madam President, we're wondering in terms of the sentencing, in terms of the calculation going forward, would it be on the 15 years before the mandate before, or is it on the sentence after the time served is deducted? It would be on the 15 years.
After we finished, if we say it is to be reduced, the court announces the sentence that should be served. We haven't taken into account 2 years spent, so we would deduct from the 15, therefore bringing it below the minimum.
Very well.
It's for the prison now. The sentence that the court is ultimately handed down is the one with the deducted sentence, the deducted years. That is how I've seen it done by the Privy Council in Gomes. And where's the case? We'll look at that. All they did, they reduced it by the time that they spent in custody and pronounced the sentence now to be whatever the court says, bearing the reduction.
Very well, my lady.
Because if we do it any other way, the prison is going to be worse confused. Thank you very much.
Very well, my lady.
We will rise. We have borne this in mind about the fact is whatever way we put it, there's an issue ERD and whether the Duncan principle could be ignited and other cases that we have dealt with. So we're going to withdraw to our chambers and determine if we give our decision now in the light of the concessions and what we would have read thus far, or we reserve judgment fully. We have to come back. Thank you. Right now, yes. We're just going to withdraw to have our discussion as to the way forward. It is now 12:17. I don't see us longer than 12:30, but we should be back before 15 minutes. Definitely before 12:30. Yes, because if we decide to reserve, we don't need more than a minute for that. If we decide to give you the decision today and reserve the reasoning in the light of what we are looking at. Thank you. But we wouldn't want to be having discussions before you, just like that. Thank you. We rise. I think to be fair, let me just say 12:30. Yes. Okay, thanks.
I was judicial clerk, my father is judicial clerk.
Please sit.
Thank you so much for your indulgence. What we thought would have been a matter of 15 minutes? Deceptively simple matter. But I don't want to say when you have so many persons. Give us the balance here. Anyway, we are happy to announce that after much discourse, as is evident by the time we have taken out, we have come to a unanimous decision. Now, the ideal thing would have been for the court to wait and produce its judgment, explaining everything and then showing our decision. But we are mindful that the applicant is still in custody and there is this issue as to his early release date, which oftentimes confronts us at the Court of Appeal. And we don't wish for that to come up, and the prison authorities are calling upon us for the decision. So we have taken the time out. We will not give the reasons for our decision today because that will take time out for us to write. But we will be giving you the orders of the court today, or the results. In order to spare you the agony of having to write what I'm saying at this time, I've asked that they are reduced to writing the orders as they are now, of course, subject to editing because we reserve that right, but just for or before the certificate of result goes out. But this is just for you to not have to write everything and for me to go more expeditiously. So you'll be handed a copy. It is being prepared now. Thank you very much. As I've indicated, this is the decision of the court with which all 9 judges have agreed. The orders are: 1, the application for leave to appeal against conviction is refused. 2, the application for leave to appeal against sentence on count 2 of the indictment for the offense of wounding with intent is granted. 3, the hearing of the application for leave to appeal against sentence is treated as the hearing of the appeal. 4, the appeal against sentence on count 2 of the indictment for wounding with intent is allowed. The sentence of 15 years imprisonment at hard labor imposed by the learned trial judge for the offense of wounding with intent is set aside and substituted, therefore, is the following. That's number 5 order. Now we're going into Roman numeral figures. Roman numeral 1, 15 years imprisonment at hard labor for the offense of wounding with intent, less credit given of 2 years and 9 months for time spent on pre-sentence remand. Roman numeral 2, having deducted the time spent on pre-sentence remand of 2 years and 9 months, the applicant is to serve 12 years and 3 months imprisonment at hard labor for the offense of wounding with intent. 6, the sentence is to be reckoned as having commenced on 10 March 2016, the date on which it was imposed by the learned trial judge. The reasons for our decision will be handed down in short order. And as I say, we reserve the right to edit this order, but this is it. So, and it only leaves for us to say thank you very, very much for your engagement and your thorough and scholarly submissions before the court. And I must, particularly on behalf of the court, thank the Attorney General's chambers, because they are usually not in this arena, but they were invited and they did not ignore the court at all. And I commend Mr. Foreman for his scholarly presentation, which certainly enriched the submissions and the experience of the court and will add much to our jurisprudence, which will be reflected, I hope, in the judgment that will come. Madam DPP, we cannot leave you out at all, and your team for your very helpful submissions and your concession, which assisted in shortening these proceedings. And of course, Mr. Fletcher and Mr. Stewart for accepting the legal aid to assist Mr. Moore in this way, because the court is really suffering from the benefit of very experienced counsel in assisting us in criminal appeals. Someone spoke to me yesterday and said, having watched it, they were wondering, how come we don't have a King's Counsel on the other side in a matter such as this? But I can't explain that, but we say, Mr. Fletcher, I said to them, Mr. Fletcher stands very well in that position. He's a very senior counsel, and we are not made any less off because of his participation, and we thank him wholeheartedly for assisting Mr. Stewart. And we just hope and pray that other senior counsel out there, you don't have to be King's Counsel, can assist us in helping us to refine and advance our jurisprudence as we aim to do the best we can for the people of our nation. So with that said, I think we can adjourn.
If I may be permitted, my lady.
And sorry, Mrs. Stewart, we are not finished.
Oh.
I have to thank all the persons who assisted us in the Court of Appeal, the registrar, because this was not easy to put together, given 9 judges. And our Judicial Counsel, our clerk, Mr. James, the entire Court of Appeal team, I must say, we have been there, and everyone. And last, but by no means least, is our IT team who have made, the members of the team have made the Honorable Chief Justice very happy, because he loves to see technology at work, and he's happy to report that this event is historic for our country, because although we have had audio presentation of our sittings, we have never had audio visual. And to know that our technology team was able to do this, we have to applaud them, and it shows the increasing capacity of the judiciary in trying to make sure that justice is done and that the public is educated about how we advance the interests of justice. So, despite what might have been initial reservations about this sort of presentation, we think it is worth it that people understand the workings of the judiciary, and they are not fed by misinformation that cause them to have less confidence in us. So I thank everybody and our police team and everybody. Thank you, Ms. Llewellyn.
If I may be permitted, my lady President, my lords, my ladies, if I may be permitted to say that during the break, we were recollecting Mr. Fletcher, who is senior to me at the bar, that he used to be almost joined at the hip with Mrs. Varinita Robertson, King's Counsel. When I first met them, the first few years, they appeared together quite a bit, quite a lot. And if I may say that Mrs. Nita Robertson would have been very proud of how Mr. Fletcher and Mr. Stewart really answered the call and really took on this matter in the interest of justice. And for my part, this is the first opportunity that I have had as Director of Public Prosecutions to appear before the still newly minted President of the Court of Appeal, and if I may be permitted to say, congratulations, and the rest of it will have to be telepathic. And if I may further indulge, given the fact that I am in the final few months of my tenure, it has been a privilege and a pleasure to have appeared before all members of this bench. May I also say to my lady Harris, my lord Fraser, my lady Edwards, my lady Williams, my lady President MacDonald Bishop, my lady Straw. It has been a privilege to have interacted with all of you at the various stages of our professional development throughout the office of the DPP. And although I'm proud of every member of this bench, my lady Simmons, my lady Foster Pusey, but I'm especially proud.
Don't forget,
I'm going to save the best for the last. I am especially proud, as I have been privileged to have observed the wonderful brilliance, the keen intellectual acuity, and the development of all of you. And I wish you all the very best, my lady President. I wish you every success, which I expect in your tenure as President of the Court of Appeal. My Lord Williams, of course you came through the stream of the Attorney General, but I've always been impressed by the quality of your writing and your temperament, a temperament which I could only dream of. Unhappily, I will never have that sort of temperament. And my lady Straw, who I met when I went to the big room in the office of the DPP, I remember that a very famous King's Counsel got very upset with her, said some unfortunate words, Mr. Knight, and we were all so impressed when she came back to the office with flowers. He had to give her flowers. Such was her dignity, class, and grace, although we were all appalled that anybody could have look at Miss Justice Straw and say anything else to her than that which was nice. Miss Justice Foster Pusey, I recall, and I hope I'm indulged because I never have this opportunity again, after 40 years to appear before you. I remember when we had our first conversation when you were dabbling a little in the criminal arena, and we had a very good conversation. Miss Justice Simmons, I knew her from she was a little girl. Her grandfather was the head of the choir on which my mother was. But everything else that I could say to all of you will have to remain telepathic. Just that you remember that this DPP, this humble prosecutor, it has been a great pride and privilege to have interacted with you. Well, if I may say, as I was talking to one Miss Claudette Thompson this morning on the phone, and I indicated to her that Miss Justice Carol Edwards, brilliant like everybody else, but please forgive me, Madam President, she will remain forever young. And she knows why I say so. Thank you very much for the indulgence.
Thank you, Madam DPP. It is a bit sad. The tenor of that speech is as if it's a goodbye departure speech.
It is, because I will
next
demit
week
office.
We might not have another 9
I
members for you.
will demit office in September. So I am in transitional management mode, but I believe it has been a great privilege, and although it was very difficult for me to pivot, to appear before you on Monday, having been in a murder case up to Friday, even Friday afternoon, it has been a great pleasure.
We appreciate that.
It has reminded me of how important mentoring is and how you must always support persons to be their best. Mr. Justice Fraser, I first met him when I was prosecuting the Queen against Sadie Franks. He was a law school student, and because of what he saw, he decided to become a prosecutor. Miss Justice, oh, I'm sorry, Miss Edwards, here is another person who is forever young. Miss Justice Harris.
Okay.
So all the very best to you.
Yes, and thank you so much. And on the note of Mrs. Valerie Nita Roberts, the King's Counsel, who is now deceased, we have expressed our expression. We have given our expressions of condolences to her in our own way, and we know she'll be missed, indeed. And we can only say, may her soul rest in peace, and her legacy lives on for other counsel at the private bar, defense bar to follow. And it is a big loss. It's a colossal loss to the system. But we have to move on. As you know, life goes on with or without us. So may her family find comfort in the memories that she would have left behind. And the court shares in their loss. Thank you. We rise.